Let's start. In this petition, the petitioner entirely seeks a quashment of order dated 30th September 2009 passed by the Chief Judicial Magistrate Jammu, by which the Honorable Court has sent the petitioner to District Jail Jammu in compliance of the execution of warrant of rigorous imprisonment para. The facts giving rise to the filing of the petition briefly stated are that on 19th September 1986, the petitioner was involved in a case and an FIR was registered against him by the FIR number 474/1986 under sections 454 and 380 RPC. The Challan was presented and the petitioner was convicted by the trial court to undergo rigorous imprisonment with a fine of ₹5,000. The petitioner filed an appeal against the order and the Honorable Court by the order dated 2nd June 2000 disposed of the appeal with the directions to the petitioner that he shall pay a fine of ₹5,000 and the fine would be deposited with the registered judicial within the period of 4 months from the date of the order. The petitioner has no knowledge of whether the family has deposited the amount and he was released from the jail. It is permitted to mention here that it is mentioned in the order that in case the fine is not deposited within stipulated period, then the appellant shall undergo rigorous imprisonment of 1 year. Thereafter, the file was sent to the Court of Chief Judicial Magistrate Jammu. The petitioner has also no knowledge about any proceeding as he has not received any notice and he was under this impression that the family has deposited the amount. That is the reason he was released from 30th June 1995. Moreover, a copy was not given to the petitioner appellant and released docket order was only issued to the concerned jail authority for releasing the petitioner of the appellant. The police station Bari Brahmana Jammu came to the house of the petitioner in an execution of warrants for recovery and the petitioner had deposited that amount of fine with the police and the SHO police station Bari Brahmana Jammu deposited the fine of ₹5,000 in the Court of Chief Judicial Magistrate Jammu by the receipt number 0946093 within bracket annexed B dated 4th June 2009. The file came up before the Chief Judicial Magistrate on 30th September 2009 and the Honorable Court had mentioned that the report received from the Honorable High Court reveals that the offender did not deposit the amount of fine as directed, so he has to suffer rigorous imprisonment of 1 year. As has been ordered by the Honorable Court, the rigorous imprisonment for undergoing the sentence be issued and forwarded to the in-charge District Jail Jammu for execution. At this stage, the offender has submitted that the police has already recovered from him and deposited an amount of ₹5,000 with the court of 4th June 2009, but the same not in conformity with the order of the Honorable High Court, so the amount deposited by return to the offender and the imprisonment, if any already undergone, shall be deducted from the sentence. It is permitted to mention herein that the petitioner remained in jail custody during the trial from 25th November 1986 to 11th February 1987. Moreover, he has already deposited the amount. Even then, the Honorable Court has sent him to jail under the provisions of Section 388 of Criminal Procedure Code. When the offender has sentenced to fine only and to imprisonment in default of payment of fine, the Honorable Court has a power to order the pay fine in full or before the date or not more than 30 days from the order in 2/3 installments, and even suspend the sentence if the offender execute the bond with or without surety. In the present case, the petitioner was under this impression that the amount has already been deposited. Moreover, till 4th June 2009, he had not received any warrants. It was only on 4th June 2009 when the warrants were received, the petitioner deposited the amount of fine with the police. So it was not the fault of the petitioner. The petitioner and his wife are illiterate and the petitioner has given the money and under this impression that this fine which is to be deposited. Moreover, from 2000 to 2009, the petitioner had not received any warrant. The petitioner has challenged the order amongst the following grounds of error. The order is against the facts and law, so the same is not sustainable. From February 2000, the petitioner had not received any summons or notice. It was only on 4th June 2009 when a warrant was received. He deposited the amount with the police, which is clear from the record, while under the provisions of Section 388 of the CRPC, the Honorable Court has power to give time or also take bound from the offender, but in the present case, it is recorded that from 2000 to 2009, no warrant was issued against the petitioner, and it was only on 4th June 2009 when he came to know about the non-deposit of the fine that he deposited the same. The petitioner is suffering because of a lapse of some other persons, as he is not an educated person and is an illiterate person, so the order is not sustainable. The Honorable Court has only mentioned that the petitioner has not deposited the amount as per time given by the Honorable High Court, so in compliance of the Honorable High Court order that the petitioner has to go 1 year rigorous imprisonment, while under the provisions there is nothing on the record which can show that any warrant has been issued while under the provisions of law, and under section 388 of the CRPC 1 month time has to be given after the expiry of the period specified, and in the present case this has not been done, so the order is not sustainable. The order is not sustainable because under the provisions of law the court has a power to postpone the payment of fine, and if a person subsequently deposits the fine amount with the court should not send the petitioner to the judicial lockup, because the moment fine was deposited in the court, and the default imprisonment cannot be imposed in the present case, since the petitioner has deposited the amount of on 4th June 2009 with the police, which was in turn deposited with the court of Learned Chief Judicial Magistrate Jammu, and hence at this stage the impugned order passed by which the petitioner has been sent to the judicial lockup to undergo rigorous imprisonment of 1 year in default of payment of fine is wholly illegal and against the express provisions of law. Learned counsel for the petitioner has submitted that the impugned order is against the law and the same deserves to be set aside. I have considered the contentions of learned counsel for petitioner. This petition is pending since 8 years. The facts of matter is that petitioner was convicted and was sentenced to undergo imprisonment for 1 year and fine of ₹5,000 by court below in FIR number 474/1986 under section 454/380 RPC for commission of crime on 19/9/1986. He files here first appeal number 17/1995, which was disposed of on 2/6/2000 with direction to petitioner to deposit fine of ₹5,000 only within 1 month before registrar judicial failing, which he shall undergo imprisonment awarded by court below. Petitioner did not deposit the fine, so warrant of arrest was issued by court below and was sent to judicial custody for undergoing rest of imprisonment. This court on 14/10/2009, while entertaining the petition, has granted bail to petitioner as he was sent to judicial custody by CJM Jammu because he failed to deposit the fine of ₹5,000 as per order of this court. It is also a case of petitioner that police has already recovered fine of ₹5,000 from him, and same has been deposited by the treasury receipt on 09/4/6093 dated 4/6/2009. The explanation given for non-depositing of fine as averred is that he has no knowledge whether the family has deposited the amount and he was released from the jail. That it was mentioned in the order that in case the fine is not deposited within stipulated period, then the appellant shall undergo rigorous imprisonment of 1 year. That thereafter the fine was sent to the court of Chief Judicial Magistrate Jammu. Petitioner has also no knowledge about any proceeding as he has not received any notice, and he was under this impression that the family had deposited the amount of petition is supported with affidavit. So I am of the view that delay has been explained by cogent means stop. Petitioner has already paid the fine. The occurrence is pertaining to year 1986 since 31 years. So in the interest of justice, it would be proper to accept the fine, though the belated stage. No prejudice shall be caused to any one. Petitioner is a married person and is about 50 years at this stage. If he is sent to jail, his family will suffer loss to their reputation. In similar case, where accused fail to pay the fine within stipulated time, Allahabad High Court in case titled Shambhu Doyal versus State reported in 1979 ALLJ 822, it has been held that under section 424 CRPC, if court suspends its order to pay fine and grant time to accused to pay fine within some time, then he cannot be arrested. Para. Hence, in view of above, the order of CJM for sending him to jail for undergoing imprisonment is set aside, fine deposited is accepted. This petition is disposed of accordingly. Stop. Thank you. Jai Hind. Jai Mera Bharat.